Michael D. Maga, physical therapist, OAH case number 2019-05-0486, agency case number 1D-2014-74838. My name is Administrative Law Judge Eileen Cohn. This is a petition for reinstatement, early termination of probation before the Physical Therapy Board of California, and the parties make their appearances.
This is Deputy Attorney General Christine Fryer on behalf of the people of the state of
Can I
California.
get you to turn your microphone on?
Oh.
Thank you. Let me see what we can do there. Jason,
You were taught that in law school, so I'm really shocked that you can't have a microphone.
All right. We are so sorry.
We're waiting for them to fix the speaker.
And do you need this for that? 'Cause otherwise I can just speak up. Unless you need it for the video.
let me turn his, that way the public can hear. Because we have a captioner.
So that can both be captured, both the petitioner and,
Yes.
Okay.
You guys are,
okay, so let's start over. But you got my introduction,
I
right?
did, yes.
Okay, and I just want, before the appearances, I just want to remind the parties that I gave an introduction before all of the cases, and I wanted to make sure the petitioner recalls that introduction and knows how the proceeding's going to operate.
yes.
Okay, so you don't need a new introduction. Okay, all right. So I think you may have to make your appearances again.
Thank you.
Okay.
This is Deputy Attorney General Christine Fryer.
Michael D. Maga, petitioner.
Okay, and the Deputy Attorney General is representing the public pursuant to Government Code 11522. Okay? Would you like to start?
I'm ready, yes.
Okay.
Thank you. Before getting to an opening statement, I would like to introduce 3 documents for jurisdictional purposes. The first is the document behind tab 1 in the binder before you. This is Mr. Maga's petition for reduction of penalty with certain personal information redacted.
Okay, so have you had an opportunity to review Exhibit 1, Mr. Maga?
Yes.
Okay, is it exactly the same that you have submitted to the board?
Yes, it is.
Okay, do you have any objections to Exhibit 1 for jurisdictional purposes?
I do not.
Do you have any objections? Are you going to also request it for all purposes?
Yes.
Okay, let's just do that now. Do you have any objections to it for all purposes?
No.
Okay, so the Exhibit 1, as described in the exhibit list that's been given to the court reporter, is marked and admitted.
Thank you. Next is the document behind tab 2. This is the notice of hearing, which I would like to have marked and admitted for jurisdictional purposes.
Okay, do you have any objection? Mr. Maga, have you reviewed this document?
I've reviewed it and I have no objection.
Okay, so Exhibit 2 is marked and admitted as described in the exhibit list for jurisdictional purposes only.
Thank you. And the last document is the document behind tab 4, which is Mr. Maga's certification of licensure.
Okay, Mr. Maga, have you had an opportunity to look at the certification?
Yes.
Okay, is there anything incorrect in there?
No.
Okay, have any objections to it being marked and admitted?
No.
Okay, so Exhibit 4, as described in the exhibit list, is marked and admitted.
Thank you. Petitioner Michael Maga was issued California Physical Therapist License number 25552 on September 29, 2000. Effective November 22, 2015, and pursuant to a stipulated settlement, respondent's license was revoked and placed on probation for 5 years. Specifically, the board had filed an accusation against Mr. Maga after he was convicted of misdemeanor driving under the influence of alcohol. He had been arrested on January 25, 2014, after he had rear-ended another vehicle. Mr. Maga was also charged in the accusation of failing to cooperate with the board's investigation. At the scene of his DUI arrest, Officers observed him to be intoxicated, and his blood alcohol level registered at .16 and .17. In the stipulated settlement, petitioner admitted to the charges in the accusation. Pursuant to the terms of his probation, petitioner has been subject to certain terms and conditions related to substance abuse, including abstention, biological fluid testing, and participating in the board's rehabilitation program. Numerous other restrictions were also placed upon his license, such as prohibitions on home care, solo practice, self-employment, or ownership, and supervision of other physical therapy professionals. Petitioner has been on probation for approximately 3.5 years. In February 2019, after a little over 3 years in the program, petitioner successfully completed the board's diversion program. He now seeks to have his probation terminated early. As discussed, Business and Professions Code, Section 2661.7 sets forth the criteria that the board is to evaluate on a petition for early termination, and California Code of Regulations, Section 1399.21 specifically sets forth the criteria for evaluating rehabilitation. In support of his petition, Mr. Maga has submitted a narrative statement, 2 letters of recommendation from a licensed physical therapist, the decision and order in his case, and numerous certificates pertaining to continuing education classes that he has completed. Thank you.
Okay, if you could stand and be sworn by the court reporter under penalty of perjury, please do.
Do you solemnly state that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Okay, you can proceed with your statement.
Okay. First of all, thank you to the board for being here and allowing me to present my case, and also Monty Martin, who really gets thanked, but the monitor has also made this possible, so thank you, Monty. I got a DUI in January 25th, 2014, and I proceeded with the criminal part of that responsibility, and I went to the 12 AA meetings, did the 3-month DUI class. And then later the board, I had no idea. I initially got a letter from the board saying that I needed to provide information. When my criminal attorney said that it's probably not going to pursue that. Naively, I hoped that was true. It wasn't until I got the accusation and settled with Deputy District Attorney Westfall that then I went to probation. As far as the terms of probation, I really took AA more seriously. We had to go into the 90 to 90 times in the first 90 days. And that's when I really signed up and got a sponsor. We started understanding what alcohol as it was. And so during that time, I developed a strong support group with AA, as well as maintaining my connection with my wife and my 2 kids, as well as attending Saddleback and having a small men's group during that time. As I worked through that process, I tried to identify what my triggers were as far as like isolating and making some selfish decisions about my drinking, which was usually only on the weekends, about when I was by myself. It wasn't until I kind of contemplated why I did that was I able to identify myself as an alcoholic and decided that was self-destructive behavior that I needed to kind of figure out kind of why I was doing that. Went to a 4-step study talking about your inventory and your fears and kind of why you drink, and that was very helpful for me also. During that time, being on probation was interesting because I had to be compliant first with the probation to then actually end up in recovery because my life went backwards. Because I was just being compliant because I wanted to practice therapy and I loved my job. But because I had to go to so many AA meetings, that's when I started really understanding alcoholism addiction. Made a really strong connection with my sponsor. He's still my sponsor. We meet still twice a month. And also friends in the program. As far as early termination request, my worksite monitor and one of my letters of recommendation, Dennis Richards, had brought me into his practice because he wanted me to at some point then take over the practice for him from the director of the clinic. That is set to his contract is done in December 2019, and the proposed date for me was somewhere January 2020, which having my license on probation would not be possible to take on that role. So that's why I applied for early termination probation.
Anything else you'd like to say?
No, thank you.
Okay, so the board's questions?
Let's start with Ms. McMillan, please.
Do you want to go after the
I'm
board?
Oh, sure, I'm sorry.
I thought, if you go after the board, then you can also consider the questions they asked.
Sure, thank
So
you.
I thought
I'm sorry,
I thought it'd be more efficient this
order.
time. Okay.
Ms.
Please go.
McMillan?
I have no question.
Mr. Walters?
What do you have as your sober date?
It is August 5th, 2015.
When did you first realize that, before the accident, that your behavior was being impacted by the use of alcohol?
I was just a weekend drinker, and probably within the 2 years before that, my wife would respond and say, hey, are you watching what you're doing with your drinking? I always chalked it up to being, it's my way to let off steam. That's the way I kind of dealt with some of the stresses in my life. I never drink during the week because my job was too important for me. So I felt that was my reward system on the weekend.
And the last question is, what is your plan to prevent this from happening again? As in, what is your new practices compared to your old practices? Just give me like a list of this is what I used to do and this is what I do now.
So what I used to do was, especially when I was home alone, that's when I'd take my time to drink alone and kind of like with addicts, experiment with that pleasure center in your brain and just feeling like life is good, that's unhealthy for me. So I'm rarely ever alone. So I'm either out with AA friends, stay in communication with my wife, I'll go out with, physical therapy friends. So rarely am I alone. Another important part for me was just to come to terms with I am alcoholic, and I have to be aware of that, because if I'm not, then I can fall back into an unhealthy state of trying to deal with stressors by drinking.
How do you feel, my final questions, how do you feel about having impacted someone else? One of the passengers got hurt in that accident. About having impacted someone's life through your direct action of, drinking and driving.
Well, being a physical therapist and treating people who had whiplash or motor vehicle injuries, awful. That's never, I got into the field to provide health and service to people who are injured, so the cause of that was relatively challenging for me to kind of deal with, but at some point you have to come to like acceptance and kind of let that go. So yeah, I felt terrible.
Thank you.
And Ms. Vaga? Alicia Rabina Amen. What would happen if you were alone? Have you had instances in the last 6 months to a year where you were alone, and what happened?
Yes, you always have to be alone at some point, but my kids are in college now. So most of the time I end up just leaving the house, going to the gym, my primary. Ironically enough, I go to the beach quite a bit. Also, I live towards Laguna Beach. And that's where I was walking on the beach with my dogs when I was drunk, and then I was driving home from that walk on the beach. But I usually like to engage in walking on the beach, going to the gym. I just try not to stay in my house alone, because that was probably my primary area where I had difficulty controlling my alcohol consumption.
Do you still have cravings to drink?
No.
What's your support system?
Sponsor, wife, those are probably my primary two. She obviously knows everything. And our marriage is healthier than ever since I've been into the program. Also, friends at work, everybody at work knows. I've told them, I actually tried to talk to them about, because obviously some of my people at work still drink. So you be careful with your license, respect your license. that I can, and so I'm with them, I make them known. I just try to minimize any type of exposure to alone time. When I am alone, then hopefully my faith comes in. You know, that's what prayer time is the primary things that I do.
Okay. And you mentioned that you meet with your sponsor twice a month or speak with your sponsor?
I meet with them twice a month.
How often do you speak with your sponsor?
I see him at least 2 other times per week because I go to 2-3 meetings per week and we always attend the same meeting. So I see him 10, 12 times a month. But we have one-on-one time twice a month. We talk about the steps. And, I do some service. I haven't had a sponsor, a sponsee, but I do coffee commitments or secretary or reading commitments with him.
Are you ready to have a sponsor? Are you ready to be a sponsor?
I struggle with that just a little bit. He's asked me if I'm ready. I'm still somewhat apprehensive to take on a sponsee. I want to be fully aware that I do a really good job as a sponsor. You know, I'm still kind of in the one of the sponsee type of mode with my sponsor. And I always want to try to read out what was the exact cause of me drinking too much. And so he's encouraged me to do that. I've considered doing that, but I have not yet felt comfortable enough to do that.
And where are you on the steps?
I finished all of them, but I still usually sit at 10 and 11 are kind of the ones that I always kind of ruminate on. So inventorying and then conscious contact with God. Those are the two I kind of end up contemplating most often.
Thank you, Mr. Maga.
Good afternoon. Just a couple of short questions. The first one, if I asked you prior to your probationary period, did you feel that you should be on probation?
I was frustrated and I struggled with that, and I have to say probably no.
And if I asked you now, 3.5 years later, do you feel that the board is justified in sort of rendering its probationary terms?
Yes, absolutely. And the whole process has helped me grow as a person.
In your personal statement or in your petition, you say that you had several offers to mentor previous aides who've become PTs or PTAs, but had to decline secondary to the restrictions on my license. Were you able, or did you just engage in informal sharing of your story when these folks were aides, and maybe use that as a learning opportunity for them
Yes.
in their future?
Yeah. As I kind of stated before, I never really even thought about getting a DUI, how that would impact my license. And so when this all happened, it gave me a greater appreciation for the privilege of having a license. And so I try to share that as often as I can with people who will engage in drinking. You know, so I'm sure they have their stories and they're probably not alcoholics, or maybe they are, I don't know. But I try to tell them what happened to me and just to be thoughtful about that.
Thank you.
Good afternoon. You mentioned you're working the steps. What is the most important step for you in this moment?
Still, I like 10 is always my favorite. Like, you know, kind of inventorying, like, you know, what am I doing? What can I do better? How can I grow? You know, is kind of the one I usually sit on the most. And then also being a faithful person, you know, then the conscious contact with God for me is, they kind of sit side to side for me.
Okay. You mentioned that you've never been a sponsor
No.
because you don't feel ready or confident that you can deliver the best services or be there. Okay.
Yes.
Okay. So you're not ready to be a sponsor, but you are ready to have a full unrestricted license. Could you reconcile those two for me?
In what means?
If you're not necessarily ready to be a sponsor, is it because you feel like you need to work the steps a little bit more? Or is it more so external, you don't want to take on that responsibility of somebody else's journey through the steps?
Yes, the second part is I like to have a high level of professionalism, both my jobs as a therapist. And I worked the steps, and my sponsor was like, well, just tell them to keep coming back. And somehow I don't know, think that that's quite good enough. At least I was someone's sponsee. That's not necessarily a great answer for someone who's really struggling with alcoholism, their life is having some real consequences that may be detrimental, you know. So the fact that I feel super comfortable doing that. Now, is I as qualified as other sponsors, I'm not sure, you know, but I have to be comfortable with that level of confidence in being able to provide the best support for that person before I take on the responsibility. Does that make sense?
Yeah. Actually, I think that makes you a better sponsor candidate because you're more mindful of wanting to be a support system, but
Yes, as a therapist, I think I always want to try to do the best possible job I can. And often I'll refer cases, you know, that I feel like I'm uncomfortable with treating. Instead of trying just to treat them, I'd rather refer to the system, either a coworker or another clinic, to get the best care possible. So that's kind of the paradigm that
I see. Okay. You mentioned that you're here today because there's a promotion on your horizon, potentially.
Possible.
Do you feel like you have been fully rehabilitated, or is your primary driving factor this new position that you're going for?
I feel like I've been rehabilitated almost to that and plus, because now I've grown in areas that I didn't even know I really had a deficit in. You know, this process has grown me, not just to have awareness for alcoholism, but also just grown me as a person. I mean, if you've ever done the steps or gone through this diversion program, the whole process makes you evaluate yourself in a very acute way. And so the whole thing has not only prepared me for, you know, taking on that role and having an unrestricted license, but also just being a better wife or father or therapist too.
Okay. Final question is, are there any terms of your probation that are particularly restrictive or prohibitive?
Most is like supervising, because obviously the role that I would go into would be supervising, you know, other therapists as well as have 2 assistants, you know, multiple aides, you know, kind of running the practice. So that'd be very challenging to have a restricted license and having those things kind of over your head, as well as all the other therapists have probably mentioned at some point, you know, I've been dropped from 3 insurance carriers, and that's always challenging to rearrange my schedule to not see those patients, because we want to keep compliant. We've always had compliance as our number one thing. And so there's aides, you know, it's just very challenging to be a director of a clinic and still have that license probation.
Yeah, it's been a challenge for a lot of our probationers to bill certain companies, and we don't really like that because we obviously trust that they're able to still practice, but insurance companies can do what they want. So sorry about that. But
Right, that's part of it.
Yeah.
I'm responsible for my actions, so
Right on.
it's part of the process.
Thank you. I have no further questions.
Daniel Drummer, board member. Mr. Maga, you completed Maximus?
Yes,
When did you complete Maximus?
February this year.
February of this year.
Definitely.
And your terms of probation were 5 years or Maximus plus 1 year, correct?
I'm not sure.
I believe that's what I read in the STIP.
I
Okay.
talked with Monty about it, and we talked about an application for early termination of probation.
Right.
So I wouldn't have asked if, you know, wouldn't want to waste your time if
No.
that wasn't the case.
No, and I mean, you're certainly in the window of being eligible to apply. Right.
I just don't know if you count your transition, so the transition years, I don't know if that was a year being out or not.
Right. Our usual term is the number of years or Maximus plus 1 year, whichever is longer. So if you completed Maximus before 4 years, then the 5-year term would be longer. Yeah, okay. Okay, and then you've used the word or the phrase that this process has helped you to grow several times. Can you give me an example of what way, in what aspect of your life you've grown?
It helped me identify the isolationism that I have, and also the kind of the selfishness I have that would lead me to direct proposal. And that was both with having to be compliant, but then recovering AA. It challenges you to kind of then see yourself, frankly, for why you make certain decisions or do certain things. when you identify those particular instances or emotions or causes, then you can kind of like go through that four-step inventory and say, okay, this is why I'm doing this. I need to address this in a very real way.
We just have one follow-up question from Ms. McMillan.
Yeah, thank you. So twice I've heard in your responses that to some of the questions that you've warned PT practitioners about the consequences of how this can affect their licensure.
Drinking and driving.
Yeah, I don't want to assume anything, but I'd like to know, did you talk to them about how drinking affects their lives and their health?
I
Too?
can't say that I've gotten into the point of, with people in AA, absolutely. People at work, no, not unless they approach that with me. And I have had someone approach that with me, and I've kind of just talked to the privilege of having a license and making sure that you respect the license, you know, and don't do anything that would be outside the Practice Act. Drinking and driving is one of those things.
Thank you.
Okay, so for the people, Ms. Pryor.
Good afternoon. You were originally licensed in 2000, correct?
Yes.
So you had been licensed for almost 15 years before you were arrested, is that right?
That's correct.
And were you consistently employed as a physical therapist during that 15-year period,
Yes.
working full-time?
Yes.
And since you were placed on probation in November of 2015, have you been employed?
Yes.
Where?
Professional physical therapy.
And how long have you worked there?
10 years of the last 12,
And
and it's the last 6 years consecutively.
In what?
The last 6 years consecutively.
you work full-time there as well?
Yes.
And since you've been on probation, have you participated in continuing education?
Yes.
Can you tell the board about that, please?
So the one class that it's also required by Maximus, I went through the 8-hour addiction codependency class with Joyce Francis. And then as the other petitioners, it's really hard to manage time-wise everything. And so I've maintained the amount of hours, continuing education hours through MedBridge and then multiple classes, all related to my practice, which is outpatient orthopedics.
And since you've been on probation, have you done any volunteer work?
Yes, we usually volunteer for our church as our primary thing. We've hosted pastors several different times. We've had foreign exchange students in our home, my wife and I. That's meetings and volunteering.
And like, when's the last time that you hosted a student?
Student just finished in last May. Mid-April,
This year, 2019?
2019.
Okay.
And we're hosting pastors next week.
You're hosting, I'm sorry.
Pastors next week.
Now, you testified that, you know, as you sit here today, you identify as alcoholic, correct?
Yes.
Do you recall approximately when you came to terms with that identification?
Probably about 6 months, after physical therapy probation started. I always felt like I have a little bit of sense of addiction-ism in me, as a lot of alcoholics do, not manifest until like later in life. So after getting the DUI, I just stopped drinking without really anything, like a year and a half. And then I had a couple of drinks when I was on vacation in Hawaii, which is my sobriety date's a little different. I didn't drive, didn't get drunk, didn't drink again, But when I started the program, and you're with the alcoholics that consistently, at first forced, and then chosen to, you kind of start understanding the disease a little better. And for me to understand the disease would help me understand, okay, this definitely is kind of an issue for me, and I just need to abstain.
And when you reference the program, are you talking about Maximus or Alcoholics Anonymous or both?
First, when I say the program, I guess the compliance program then brought me to the Alcoholics Anonymous program.
Because Maximus, they mandated that you attend a certain number of meetings a week, is that right?
Yes.
And did they also encourage you to do the 90 and 90, which is 90 meetings in 90 days?
They not only encourage, they require it.
And through that involvement in AA, which had been mandated by Maximus, that's how you came to terms
With my alcoholism.
with alcoholism. Thank you. Do you keep alcohol in your house?
Yes.
Because you testified that being home alone is a potential trigger, is that right? Have you considered removing alcohol from your house?
So after I got the DUI, for like the first 2 years, it was all out of my house. But within the last couple of years, my wife has bought it in for her, obviously, in little bits and pieces. So we'll have a bottle of wine, in our cupboard occasionally, but not being a significant amount.
Now, you completed Maximus in February of 2019, correct?
Yes.
Which means that since that time, there has been no requirement for you to attend Alcoholics Anonymous, is that right? Can you tell me about your participation in AA since you completed Maximus?
I continue to go 2-3 times a week in the same group that I've been going to for the previous 4 years. And the same sponsors, so see them, say 12, 14 times a month. Continue to work the steps together.
After you completed Maximus, did your program of recovery within AA change at all?
No.
Same meetings, same sponsor?
Yes.
Do you take chips at meetings?
I did.
And what's the last chip you took?
I took my 3-year chip, and 4 years coming up.
And if your probation is terminated, is it your intention to continue to abstain from alcohol?
Yes.
And to do that through participation in AA?
Yes.
Do you have any concerns that if you are no longer subject to biological fluid testing, that you will relapse?
No.
Have you relapsed?
No. I'm still biological tested. No.
Since you've attempted to abstain from alcohol, you have not had a relapse?
No.
And you understand that the purpose of probation is public protection and rehabilitation, correct? And another question I'm going to ask. How can the people of California be assured that you will not present a danger should your probation be terminated now?
As the other petitioner said, it's never for sure thing, but as far as so far staying with AA and being consistent with what I'm doing and making sure that I minimize exposure to being alone and make sure I deal with my stressors, triggers consistently, I think there's no issue.
I have no further questions.
Okay. Is there any closing remarks at this point? Well, first, let me ask, did you have any follow-up to our questions, that you wanted to make any statements, follow up to the boards, or
No.
further questions? No, okay. All right, so you want to make your closing remarks.
The petitioner has testified that it was through the Maximus program which mandated him to go to Alcoholics Anonymous, that he came to terms with his alcoholism and has progressed upon this path of recovery. And that's a direct result of his being on probation with the board. Petitioner completed that program just this past February. He's been on his own in terms of his recovery, in addition to the biological fluid testing in that time. And he needs to finish his probation. This is not the time for the board to test out petitioner doing this on his own. Probation has been very helpful to him, and he should complete that term.
Okay, any more remarks? Mr. Mack, okay. Thank you. You're both ready to submit to the board the decision?
Yes.
Yes, okay. The matter is submitted and the record's closed. Thank you. And now we're ready to go into, we'll take a few minutes, we're off the record. We'll take a few minute break and we'll go into closed session.
You're pulling 3 and 6?
Yes, thank you.
The time is 5:07, and we're going to pick up with agenda item number 7, the legislation report.
I think we can make this pretty brief. I'm going to do my best to kind of supplement and fill in for Brooke Arneson, who's not able to join us right now. So I'm not going to be able to present the materials as well as she normally would for you. But the materials that you have in front of you include a couple new items, but we'll start with the first. Just a calendar update. We're really looking at August 30th being the last day for the fiscal committees to meet and report the bills, and that's after they reconvene after their summer session. But the last day to amend bills will be September 16th, and then the last day for the House to pass those bills on is September 13th. The thing that you'll see in the materials that's a little bit different is we've changed the format and the way we report the bills and where they are status-wise. And so there's a little bit more of a visual element to kind of clue you in on where they are, first house, second house, or what committee. A brief summary of the actual bill language itself. But then all the materials are hyperlinked to the materials if you want to drill into them a little bit deeper and see the bill analysis or the language of the bill itself. Staff doesn't have any recommendations for positions on bills at this time, but we're happy to answer any kind of questions that you might have on any of the bills.
Are you going to go through the bills one by one, or no?
I can if you'd like.
What do the members want?
Are there any that we should have a brief description of? Perhaps others we don't?
I can bring a couple bills to your attention that I think have the greatest impact on the board. And so probably one of the bills that has changed since the last time that we discussed it was AB 193, and that's a bill that the language is very familiar to you. It's usually brought to us every legislative session, and it talks about looking at the board's regulations and determining if there are any unnecessary barriers to license. That bill's actually died in committee. AB 476 is a bill that speaks to foreign trained professionals and may impact this board if that's put together, and it's something that we would be included in the language in participating in that task force to determine if there's any unnecessary barriers to license for those that are foreign trained. AB 496 is a bill that would affect us in the sense that it would be opening our Practice Act to change some minor edits to gendered-based terms to then replace them with non-gender-based terms like licensee or licentiate in replacement of his or hers or that kind of thing. So any questions on those?
Yes, the last sentence or the last phrase provides that each appointing authority may remove its own appointees from a board. Is that not in place now?
have to look into that one a little bit deeper. I don't think that applies to us. There may be some boards that actually have the power to appoint members to committees. An example might be the Veterinary Medical Board's multidisciplinary committee, and so they would be able to remove somebody from a committee, but I'll have to look into that to confirm.
Okay.
Moving on.
Yep.
AB 544, which is inactive licensing fees and accrued and unpaid renewal fees, could impact us, but that also failed the deadline and died in committee. AB 613, Professions and Vacations, Evan Lowe is the author, and it is a bill that is designed to, every once in a while, allow the board to take a look at its fees and increase the fees based on the cost book for the state of California, essentially trying to adjust for inflation or other overhead type of costs. We would be included in that language. And I think it's something where they've heard through sunset processes that boards have struggled over time to adjust for those kind of things in their fees. Fees are difficult to raise and difficult to justify, and this would just be another tool for us to address that issue.
So I have a question regarding that. At current state, we're at cap. Our current level is at cap. And I didn't get a chance to read through this legislation fully. Do you know, does this allow modifications when we're already at cap, or is it intended to be more of just a kind of adjustment along the way without having to do full regulation?
I understand. I think there's a lot of discussion that's been had about that because it's a separate vehicle and a separate statutory authority. The statutory caps that are imposed in a practice act for fees, this would supersede those because it's addressing that particular issue of cost book and inflation. So while we're at cap, this would say we could increase the fees, which is usually an average of about 4% for cost book. So this would actually supersede that authority.
And Dr. Jummer, Michael Kenotes here speaking. Also, the bill would provide that these fee increases are not subject to the regulatory process. So it would allow the board to increase those fees without going through the specific regulatory process.
And there is kind of a lot of unknown in the way that bill could play out if it's approved, as far as where the text would be. Is there going to be text that conflicts in statute with other statute text, and how that actually would be displayed to the public? That hasn't been addressed yet.
And the limitation and increase would be tied to the, what did you call it?
The California cost book.
The cost book. So changes would likely only be incremental of a few percent, as opposed to larger scale changes, which has typically been done in the past.
That's the intent, for that purpose only. It doesn't change the normal promulgation regulation and increase in revenue or increase in fees in any way. It's just adding a second vehicle for that.
So at current, as an example, a PT license renewal is $300 for 2 years. The next renewal potentially, if this were to be adopted, the next renewal could potentially be $312.
Exactly.
And 53 cents. Thank you.
Yes. Any questions on that one or next one?
Yeah, I just want to invite the public to come forward. If you have any comments on anything that we're discussing, please come forward to the microphone.
So the next bill on the list is AB 1076, and this is criminal records automatic relief. This bill affects primarily the Department of Justice and the criminal background information that we receive from the Department of Justice. Currently, licensees with criminal records, as part of their application process, provide their fingerprints to the board in a kind of a subscription process, so that if there's ever any kind of subsequent arrest or conviction information, it's relayed to the board so the board can determine whether or not it's substantially related to the practice. In place right now, there are systems of relief that a licensee can apply towards that local jurisdiction sometimes after 12 months, sometimes after 18 months, to have that conviction expunged from their record. This bill would say, instead of it being a application process that the licensee would have to initiate and then have approved by the jurisdiction, would make it an automated process that the Department of Justice system would just look for that time frame, essentially apply for it for them and approve it, and remove that information from the criminal record that the board receives. So if they meet the criteria for the expungement, it would happen automatically, and it would not be something that would be relayed to the board. We would not be aware of it.
So it's a change in the process.
It's a change in the way the system, it's a change in the process, and it's a change in the way that the system works for the Department of Justice as well. So essentially, we wouldn't be made aware of a good portion of the different convictions that we're made aware of now.
And it says with specified exceptions. Do you know what that is?
Right now, it's a broad term in the sense that they're going to have to determine with all the different boards and bureaus or professions, and even entities outside of the Department of Consumer Affairs, what exceptions would need to be made in the future.
Could exceptions be something that we normally wouldn't make an exception for? Our board would normally not make an exception for?
I think what they're trying to determine is specific professions that it should not affect, that those convictions should still be relayed to those boards or bureaus regardless. And so they're trying to identify those professions that require exception now, that they may be doing so might be a harm to the public if the board was not aware of that information.
Any board comments on that or concerns? Any public comment? Okay.
Let's see, so the next bill that I think that I would bring to the attention of the board is SB 53, which looks at the Open Meetings Act, and the language essentially would require that any committees that the board would form with 2 people or more would now be subject to Bakley-Keene or the Open Meetings Act. And so that might create a hindrance for boards utilizing those types of committees, creates a difficulty in logistics. It adds to expenses in the sense that anytime that those 2 members meet, that we would have to, in advance, notify the public of that meeting, make that meeting publicly accessible, which logically would incur increased costs and extend calendar timelines as well.
Is there a sense as to whether this would apply just to specific called meetings or structured meetings, committee meetings, as opposed to 2 board members who are together talking about the issues before the board?
So it would have to be a formally established committee. But having said that, there is some kind of vague language and concerns that have been expressed by other boards and bureaus that could be interpreted to include a lot of the day-to-day business that they call a committee, but isn't necessarily established in any kind of regulation or authority. So it could include some others.
Good afternoon.
Afternoon. My name is Mitch Kay, I'm a physical therapist. I'm representing the CPTA, and I just have a question. Excuse my unawareness, but what does it cost to send out a notice about a meeting? Is it electronic, and what other expenses would be incurred?
So in this sense, logistically speaking, the cost of actually noticing the meeting really isn't much. It could be sent out electronically. It's more about how many days in advance of the meeting and just kind of organizing a calendar that would make those meetings publicly accessible it just adds a layer of difficulty. And then to make that meeting publicly accessible and having the venues, or reserving or providing the venues for those public to attend, and then the electronics, broadcasting, webcasting, those kind of things, the cost could add up a little bit.
Comments from board members? How do you guys feel about this?
I don't understand the spirit of it. And, you know, I feel like, so if we're sitting on a committee and me and Dr. Drama wants to meet suddenly, we would have to.
Use your microphone.
We would have to. Okay. The spirit of the bill is, if we have a meeting, say our committee meeting, and now we have to give notice of the meeting and publicize it and all of it, and maybe it's an hour-long meeting. I want to see more about how do they really define when it meets some threshold where we could just talk in that committee, or when is it like a public notice meeting? What is that definition? What is that threshold? Or is it always just like a duly noted meeting? Because if it's a duly noted meeting, then what's the point of having committee meetings? Unless it becomes exceptionally important, if you're really big, that you have to have this.
Essentially, the intent or the spirit behind this bill is just that, is that anytime that committee meets and discusses business that as an example with the Department of Consumer Affairs, affects the regulation or the profession that it regulates, that the public should have an insight into what those discussions are, and it creates that level of transparency, right? So if that committee is going to have those kind of discussions at any time, that would be open to the Bagley-Keene Act, and you would have to notice it, and you'd have to have public accessibility and participation.
My concerns are the ability for the board to be nimble and work on board business or handle board business in between board meetings, such as the committee that me and TJ are on. It would be really difficult to have to notice every single one of our conversations and provide space for the public to participate and give feedback. I understand it's for transparency purposes. Certainly that is important, especially when you're making decisions using government funds. So don't get me wrong, I just think that the governance piece of it and the logistics piece of it will actually end up costing us more than what we will save as far as what is disclosed and not disclosed. However, there are some boards that maybe could benefit from this. I'm wary of blanket policies that affect everybody when really it should be directed towards who it should be directed to. So,
and I think there's an element of that here, like a broad brush approach to address an issue that's not necessarily rooted at the Department of Consumer Affairs, right? So the committees that are utilized by boards at DCA are usually not decision-making committees. They're advisory committees that then bring that business back to the full board for a decision to be made. And so there is an issue of filtering that's a concern there, and maybe the transparency can be applied to that, but the decision itself is not being made by that committee. And there may be other departments where the decisions were being made by those smaller committees, and this bill is addressed to that specifically.
And I would wonder if any two board members wanted to meet with other government agencies that we work with. So if two board members wanted to speak with the director of DCA, or with agency, or with a department within DCA, HR, or legal affairs. So now that becomes an open meeting where the public's going to attend that and, you know.
Yeah, I think that trying to imagine what this would play out in a real world setting would be is that if those two members were appointed to an advisory committee, that the discussions with that third party would fall under this, and you would have to do it in a public setting and follow Bagley-Keene.
So how would that work if two board members wanted to discuss the EO evaluation? Now that's all public record, and you would be able to read or potentially watch our conversation about your own evaluation?
That's a good question.
Like-
If they weren't actually an appointed committee, I think there's an exception there for that. But I think I agree with your comment about it. It removes the board's ability to be flexible, nimble, and utilize a smaller committee to address smaller issues and bring those issues to the board with a recommendation and let the board make a final decision. So I think that logistically speaking, it could gum up the works quite a bit. It would be problematic, to say the least.
Is there a board member here who would like to recommend a position on this bill?
It's a little early, isn't it, to take a position?
We're in the second house.
So the Board of Accountancy is the only organization that's taken an opposed position to date?
Today, but we're also kind of in the season of board meetings. So I don't think we have insight into the meetings that were held last week and the other meetings that are also being held this week.
So the Board of Accountancy is actually opposing the bill?
It is.
Any board members feel one way or the other about this? It's our time to say so if we feel this way.
The Board of Accountancy is a large entity and does utilize a number of committees to conduct its business, so I could see where, for them, it would be significantly more difficult than it would be for us, per se. I mean, we utilize committees, but they run off of some of their committees for scheduling and other kinds of issues, having board members present all at the same time, those kind of problems. So I could see where they would take an oppose.
It's sort of a precarious position, because if you oppose it, it looks like you're opposing transparency.
I think the opposition argument is a valid argument, though. I don't necessarily think that the first thing that you should look at then is that board is then, somehow trying to hide something behind a veil. I think it's more, if an opposed position was taken, the rationale that we used in that letter would be legitimate rationale.
Yeah,
I mean,
it's very similar to what the accountancy board has. We're just trying to get work done.
Mm-hmm. Yeah.
And so I can't think of any amendment to the bill that I would suggest. And for the reasons why we actually utilize our committees and I guess subcommittees, I would feel comfortable opposing this bill. I don't hear a lot of talk from the board members, though.
I'd be okay opposing this as well.
Dr. Dominguez, Dr. Drummer, Ms. McMillian?
I was going to say real quick that I'm trying to think back, how often have we utilized advisory committees, and do we feel strongly that this would be a hindrance to normal operation? In other words, does this rise to the level of really, not, in essence, crippling our ability to conduct business?
Mm-hmm. Yes.
Well, I think what will end up happening is you wouldn't want to have these committees Because, just giving public notice to those meetings that may or may not even last an hour, we would start having to come up with new ideas of remedying certain situations that may legitimately require a committee. And this is definitely one of those situations that I can see how it could be applicable to other spaces, but to this specific board, not so much. And that we're not opposed to transparency at all. We just look at if you're a smaller entity and you have to utilize flexibility to get decisions made and, bring new information to the board so a decision can be made with new information, that would definitely put a hindrance on it. So.
And this bill, the situation is a little precarious because it's always been the nature of this board that if you were to take an opposition, that you were always looking for an opposition with some kind of amendment. And the language is simply, moving from 3 to 2. So there's no amendment to be made per se. So, and to Mr. Watkins' comments, I believe you'll see in the analysis from the opposition for accountancy, they address some of those same issues, that this would serve as a kind of a disincentive for boards to utilize committees in any way because of maybe for larger, more controversial issues, they would go about doing it because they want that involvement at all times anyway. But for some of the smaller things that they need to address, this would be a disincentive for them to utilize that tool.
We've had, I can think of multiple occasions in the past where we've had 2 board members go to, different government bodies to discuss things specific to the physical therapy board. And I can see, it's great that 2 of us can go together. I can see, I don't know, a disadvantage to just sending one,
Also, while we may not be exercising committees or utilizing committees as often as some other boards, as we grow, that might be something we want to do. And why not speak up now if this is a potential issue that we might face in the future?
Is there a reason that we're just now discussing this? Because it's already made it to the second house. And
it's actually not new language. It comes about every legislative session, and it's again, it's not something that really addresses the Department of Consumer Affairs or the boards and bureaus within. It's the focus of the bill is directed at a different department for a different issue.
And the reason why I say that is because we're attempting to have this conversation on this bill, which I'd like to look into further, even though it's late into the game before I even speak up about it, because I'd like to know, what the opposing side is saying, what the support side is saying, really see how it affects the physical therapy board directly or indirectly. So that's why I'm not having a lot to say, because I know bills need to be looked at and read through thoroughly before you decide to take a side.
It is here, the analysis and the support and the opposition is here in our meeting materials.
And then I will look at it. But I'm not going to make a comment on it. I'm not yet.
My comment still stands. I'm willing to oppose the bill. Dr. Drum or Dr. Dominguez, any comments from either of you?
I've been enjoying the conversation. I believe we had a little bit of discussion. We might have had a little bit of this discussion at the March meeting. If not, when this has been brought forward in the past few years. Of note, and it's noted in the materials, that Governor Brown did veto 2 separate versions of this, believing that stating that there is adequate protection at this point, and that the advisory committee aspect of this is something that they're not decision-making committees, and that the people are protected still because they are not decision-making committees, which might be an amendment that would be a more appropriate, make this a little bit more palatable. Because if they're making decisions, then by all means, then the public should be aware of it. But if it's advisory and that material is coming before the full board in a noticed meeting, then I see this as a little bit onerous.
And I would just add to Mr. Kaiser's point, opposing without really having a good sense of what, modification we might be interested in. I'm not sure about that, because it is just literally a reduction from 3 to 2. And so what modification to this bill might we consider and still be comfortable with 3 going to 2?
And did you have an idea on that, Dr. Drummer?
I think, if we were to oppose unless amended, and to make a suggestion for the amendment, it would be to modify the word advisory to action committee or something that would imply that the committee has more power than just being advisory. I don't know that would go anywhere with offering that as an amendment, because that's something that's been brought forward on multiple occasions, and it's included, I believe, in the Board of Accountancy in their opposition.
And to provide a little bit more context, this board in the past has never really taken a position against this language in its other forms in previous sessions. Again, that might have been because of our experiences with the sitting governor at the time and kind of knowing that he had vetoed that language before. With the change in administration, I think it's left some of the boards thinking that, well, accountancy being one of them, that it's important for them to voice their opposition to that concept or that idea.
So then the question becomes, is it important to us as well? If we've never taken such a position, do we think that, on a broader level, that the current governor will take a different position than the previous governor on 2 separate occasions? And more interestingly, what do they know that we don't?
And of note, it hasn't made it out of the second house yet.
Yeah. So the current Watts position as recommended, you want to hold on that position?
Should things progress and look like it might be something that is going to be adopted, that would be signed by the governor, when we're closer to that time, we have the ability to call for a special meeting in the end of August to address legislative issues if we needed to do that. That could be an option for us, to wait and see how things are going for right now and then make a decision a little bit later on after this discussion. So we aren't necessarily under any point of pressure at this point to act on it now, that it could be something to, if it rises to the threshold of calling a special meeting, any of these items, we could do that. Suggestion.
Yeah, how would we define when it rises to that level, when it moves forward? Because the way else is...
Yeah, paying attention to the status of it, having our staff keep us appraised of where things are. If we want to do a little more scrupulous watch, or watch to the nth degree, however we want to turn up that dial to keep us appraised of it a little bit stronger, we can ask. I think that we could reasonably ask staff to keep us updated.
Absolutely.
So we can use our agility and our nimbility. Huh?
Moving on. So there's only one other bill, I think, that has an impact to this profession, and we actually have a member in the audience that represents the association that championed this bill.
Unprepared by it.
Okay.
Mitch Hay, as a therapist. The CPTA has introduced this bill, SB 537. It's been entitled Workers' Compensation Bill. Currently, what's happening in the workers' comp arena is that there are,
Sorry, I think you're okay. I think let's try that.
there are groups of payers that have dwindled themselves into positions where they can profit from a claim that is being, or treatments that are being recommended for a workers' comp patient. The state's workers' comp fee schedule is, I believe, above the Medicare fee schedule. And these third-party payers come in and grab some of that money, and so what is left over for the providers is much less than what the fee schedule is. And so this bill is trying to stop that from happening. Some of the organizations that are doing this, one's called One Call, the other is I can't remember their name right now, MedRisk, and they siphon a great deal of money out of their, from the therapists. They recode what was provided to the patient when the therapist bills them to a higher rate, collects the money from the payer, then they revalue the code back down to the therapist. And so this is what this bill is asking for, is to close that so therapists can be paid appropriately for what they're doing and not have all these other people coming in and grabbing the money. There are radiologists, there's a third group, physician group, that is also in having the same problem with their workers' comp cases. And this is currently, it's passed through the Senate and is in the Assembly now, and it, I believe, the middle of July will be heard by the insurance or the, was it appropriations, Mr. Kaiser?
Yeah, I can grab you that really quick. The next stop should be the fiscal.
The appropriations.
Yeah, Appropriations Committee.
Okay. So that's where it stands right now. We believe, the chapter believes that the Senate, it flew through the Senate. There were no opposition was cited at all. But we believe in the Assembly, especially when it gets to the insurance and the appropriations committees, that it's going to become unglued, and we are worried that it'll be amended that it'll be less effective. We have no other knowledge at this time. I believe the chapter is having a meeting on Monday in regards to amending the bill because of what the insurance companies are bringing forward. So we would like some support from the board.
Board comment? I do support the board taking a support position for this bill.
Jason, can you provide some insight as to why staff recommends a watch position at this time?
Summarily, essentially what we're talking about is compensation for the practitioners themselves. And I don't believe that, regardless if this bill is successful and creates a change or doesn't, that it will actually affect the costs that are being passed on to the patients that we represent, the consumers that we represent in the state. And so the only reason that staff hasn't brought you any kind of recommendation is it doesn't really quite fit into the perspective of a consumer protection issue. Having said that, we don't oppose it either, right? Staff is essentially neutral in this situation when it comes to the language that's encompassed in this bill and the perspective that it comes from.
Thank you.
If this practice continues, would the number of workers' comp physical therapists who provide services for workers' comp patients potentially be decreased? And so then patients who are covered under workers' comp would have a more difficult time trying to find providers, physical therapy providers who are capable of taking care of their needs, their injuries?
I think there is just a basic supply and demand issue at that point, economically speaking. As long as the MPNs are whittling away at those rates, if there are PTs to fulfill that void, it doesn't actually affect the consumer. But as time moves on, if the PTs start to not accept that caseload because it doesn't pay, commiserate to what they might find in private practice or third-party payers for insurance companies, that certainly could happen.
I do believe that consumers do not always get timely care because of this issue. The agency that I work for can only accept so many workman's comp. They have to balance out to make sure that they're getting enough revenue coming in. And I have seen patients for home health care more than 1 week out from when they're discharged home. So there is a demand, and I think there is some thought from agencies to accept these cases because of the low payment. So I think it's probably already happening.
You know, as I'm glancing through this, there's one more area that you didn't share with us, which I think should be pointed out also, and it's saying that it would prohibit the administrative director from even investigating the complaints or even take enforcement against these third-party payers. So, if I'm reading this correctly.
What page are you on, Tanya?
I'm actually on the California Legislative website.
Okay.
So that means that they will continue to get away with it, and nobody would be able to even address them, or investigate them, or stop them, am I correct?
I'm sorry, I can't speak to that. That's new to me.
Yeah.
If I may, in looking at the bill, it looks like that language is taken out in that spot and replaced later on in the same section. So
Okay.
it looks like they're reorganizing the section there, but it's certainly confusing the way it reads. But
Yeah.
later in the bill, that same language appears as subdivision I, or later in the same section.
Okay.
So it looks like just a reorganization there.
But the language is still legitimate, though, correct? Even if it's in a different section?
Correct. It looks like this was reorganized.
What page of the bill are you guys on?
Okay, let me go back.
I'm looking at the today's law as amended version online, so it doesn't have page numbers, but it's
Yeah, it doesn't.
section 7 of the bill that's amending section 4616 of the Labor Code, all the way at the end of that section. It may be in plain type, but subdivision I is the same language that used to be in paragraph 4 of subdivision B. For some reason, someone thought it was a good idea to move that.
From my perspective, I feel there's this dividing line whenever you're talking about compensation and all the issues that pertains to the actual profession that you are bordering on, exiting the public mandate, protection mandate. And I mean, me personally, would like to see some stuff that pertains about how the public, which we are mandated to protect, will be impacted by this, if any, in the short term, medium, or long term. I can see obviously the feel for it from the profession side, but I'm trying to understand the next component, the public protection side, which is the side that the board represents.
Thank you for your question. The way these third-party payers work is that they go out and sign contracts with providers. And some of them get placed on a list, and it's a tiered system. The less you charge us, the more patients you will receive. And so the therapists are beginning to not sign up with these large agencies or insurance providers, third-party payers. And so the wait time to find therapists that will take those low fees is diminishing. And so the wait times have really increased in many areas of workers' comp. So that they're the customer, the patient is really at a disadvantage trying to find coverage, local coverage for themselves. These third-party payers have the contract so that if an injured worker goes to a physician, the physician sends their report to an adjuster, and the adjuster has only a limited number of therapists that they can refer, then the patient has to wait. And then plus, if it's a hand patient versus a knee patient or a specialty area, that's even more difficult. There are hand patients that the doctor orders PT for or OT, and they can't find either in their areas. And so what's happening when I've gone out and answered complaints for the board, when I hear from my members or have complaints received from patients, is that the type of care or the individuals that accept those very low fees provide very minimal services. and they do not meet the standard of care, the community standard of care for those injured employees.
So what you're essentially saying is that if, as an example, if we take a support position and this bill actually goes through, that it will benefit, obviously, first of all, the physical therapist, and secondly, as a result of that, it will benefit downstream the consumer.
Well, in order for it to benefit the therapist, they have to be paid appropriately, and then, yes, the consumer would have more chances or more availability of care.
So the potentiality of getting shorter wait times will then increase.
Correct.
Okay. Thank you.
So they would be getting more availability of care and a better quality of care too,
I
correct?
believe so. Most of these third-party payers pay a therapist less than it costs the therapist or the office to provide the care. And they're limited in the number of visits. Usually the procedure is that for a workers' comp patient, the approval is for 3 or 4 visits. And after that, the therapist has to do another evaluation. And then the delay between the evaluation, the adjuster getting the evaluation, and extending the care is a long time.
Amen, 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 amen. It's so frustrating. It's very frustrating when you have a patient before you who needs care, and you're qualified to give them that care and to help them progress, and you can't do anything. You're not allowed to go back out there until you get the authorization, even though your original evaluation said, 3 times a week for 3 weeks. You can't go.
And the workers' compensation rules do not allow a patient to pay for their care, even if they want to, unless the adjuster has closed that case. So the patient's really up a creek.
So is a legislative solution the only solution to compel these third-party payers to adjust their ways? Is this the only way?
Evidently so. They do respond to the employer when they go to their insurance company to say, this is what we want covered with our employees. They still want to collect their large sums of money for doing nothing, to be perfectly honest with you. They're just a hand in the pot that they've been able to gather some of that money that should be going to the people that are doing the work.
Well, I'm very curious to see how they amassed that level of power. Who granted them that amount of power? Because if you want to level the playing field and it is market related, and the market has obviously rewarded them to play at this level, then if we go a legislative solution round, what would their reaction be to this? And, I'm actually asking because I don't know.
If they can collect as much money as they're doing now, I'm sure they are looking for ways to continue to get that income on the backs of other people.
Yeah, this is quite interesting.
Many of these companies have created themselves under the guise of being able to better manage the care and the cost of what's being provided to the patients on behalf of the payer, on behalf of the insurer. Medicare, for example, uses organizations, groups to manage the care because CMS itself is too large of an organization to be able to manage the individual payments out to specific providers for the services that they give to the patient. And so there are different companies across the country who do this. And these companies in California have established themselves as in the guise of being able to better manage the cost and the provision of care so that providers are not being onerous in the amount of visits that they're providing and jacking up the number of reimbursement requests that they're submitting.
This is a really interesting intersection of when capitalism meets
Yes.
healthcare.
And that's my point, you see. If you enter, if you have a public protection mandate and you enter into this space, right, where it's a market-driven, call it an advantage or exploitation, you can use whatever words you use, that they're sitting in this position right now. And legislatively, we want to compel them to do a particular, go a particular route. I'm right on the border because I'm trying to see where the boards start, the board's responsibility begins or ends, and the associations, obviously, that has way more skin in the game protecting the members to against such practices by these third-party payers. I think that is an important deal. I just can't find that line. For me, it feels like it just may be slightly outside of our mandate, but I'm willing to listen.
May I ask, at the prior hearings, I know that folks come and testify. Have these third-party payers, have they had folks come in to testify on their behalf?
What I've heard is no, they have not shown up for the Senate committee meetings. But the board is just, and we're just waiting to hear what happens in the assembly. One aspect of this is that if I'm an employer and I want to self-insure, I will pay for my injured employees' treatments. So I find someone like the One Call, and they say that they'll save me money. The Medicare will pay, the Medicare fee schedule, which the workers' comp is based on in California, will pay $150, for example, for an evaluation, and will pay X amount of dollars per visit. And then, so this third-party payer goes to the employer and says, I'll save you 20%. It'll cost you 20% less than if you went to a physical therapist that does not come through our network. And so then that third-party payer takes their portion and has a list of therapists who have signed contracts to provide the care for a very minimal amount. And so that third-party payer is gaining, the employer's gaining, and the insurance industry, the laws in California allows that to happen. And it's across the country, it's not just in California. So what happens is that the patients, more and more therapists can't afford to treat a workers' comp patient, not just the less money that they receive per visit, but all the paperwork they have to do to try to make sure that that patient receives adequate and the best care that is coming to them.
Excuse my interruption, guys. We're going to lose captioning service here shortly.
Okay.
Please don't let that affect the meeting at all. I just want to...
Thank you, though. Ms. Elby had asked me why no position was recommended by staff, and I think I remember I said that we were neutral, and we certainly saw the benefits of it, but because of the perspective of which the language is written, staff wasn't providing a recommendation. that's twofold, though, right? We're not providing an opposition either, right? I don't see a detriment to consumers identified if this was successful. And so, again, staff is neutral in the sense that this isn't something that we would bring because it's not in the purview of consumer protection, but essentially, it's not something that we would oppose either.
Is this one call care management a California company or is
It's
it
based out of Florida.
Is it based out of Florida? Okay.
I would like to recommend that the board take a support position on this bill.
Is that a motion?
It's a recommendation for now, considering we're still discussing, but I just wanted to share my opinion. I think at the end of the day, it is still a public protection issue if workers' compensation patients are receiving less quality care and don't have as much access based on the things that Mitch has shared with us. So I can support this.
May I ask Michael? New counsel, I'm learning names. Okay. So my concern is, where is the enforcement piece if these third-party folks, what's going to make, okay, so once this becomes statute, if it does, that doesn't guarantee that these third-party folks are going to quit. And that's why I'm looking to see what kind of enforcement is in place or anticipated to make sure that this is obeyed.
From my reading of the bill, there's no specific administrative enforcement provision provided. However, if the contracted rate is less than the applicable Medicare fee schedule payment, it would be an illegal contract under this section. And certainly there would be both a private ability for perhaps, there's a little speculation here, for private parties to forge a cause of action against such a contract, or the Attorney General could certainly step in to enforce this provision, as the Attorney General is charged with enforcing all California statutes. But you're correct in saying that there's no specific enforcement provision here, and frankly, that would probably be, this isn't a provision I would expect to find an administrative enforcement provision attached to.
So is it safe to assume that when this passes, if this passes, that the real outcome would be to deter providers from signing up with the third-party networks?
I can't say that would be the outcome, but the
there's no incentive.
The legal outcome of the bill would be that any such contract would still have to be for the Medicare rate, but I think
The sections that are being amended here currently are under the jurisdiction of the workman's comp system, though. So if this is codified and this is created in statute, it would certainly be the policy of workman's compensations and their investigations and their administrative branch to enforce that portion of it. And so those companies that would be in violation of these new codes, as an example, the rates or the ability to alter the documentation or alter the plan of cares, if they found violations of that, just like any other type of violation that they found here, they'd be able to use the same kind of administrative actions against those companies.
I believe it's the insurance companies that are the ones that, the insurance agencies here in California that have sued, It was a federal case recently with one call, and they were found to be in violation of the federal laws in regards to insurance as the tiered system that they were using, and they were told to cease and desist, and they haven't. And so the CPTA has taken or issued, caused the federal government to take action against these companies. They're slow in coming. The decision was they were to make it, they're not meeting the decision that they signed up for, and the problem still continues.
Mitch, am I reading this correctly? This, if it were to be created into law, would not go into effect until January 1st, 2023?
Correct.
To allow current existing contracts to expire? Right, okay,
Yes.
thank you.
And I know I sit here as a board member, but I bring my physical therapy experience with me, and I see patients with all sorts of insurance. I see patients pro bono. I don't always see patients just for the money. I need to make a living, but I don't always see patients just for the money. But I see this playing out in real life. I see these patients having to wait to get the timely care that they need. And so it's very much so a consumer issue. If the companies who send their employees out to see these patients who are on workman's comp were reimbursed the rates that they deserve, they would probably accept more of these patients, and these patients would be seen more timely.
And therefore get better care.
I make a motion in support of, what am I saying? Of supporting this, yeah.
I just want to reiterate before you...
I made the motion.
Okay.
Somebody has to second it, then we can discuss.
Okay. Well, I'll second it.
Now you can discuss.
Okay. It becomes really tricky when you have a commercial venture like this taking place and intervening when your mandate is public protection. If the first line of that is the physical therapy profession, and an indirect part of that then becomes the public being affected, then a neutral position holds better in alignment with the public protection mandate. If it was the other way around and the public was immediately impacted by this without an economic benefit to the profession, it would be less blurry, in my opinion. And so the neutral position protects the board as that public protection mandate authority from, if you support it, you fall off to the one side. Now it can also be viewed that, okay, you're protecting the profession and want to help the profession, a good cause, but outside of the mandate, because it's not the first line of what it is in the public protection mandate. If it was these patients are now being exploited directly by this third-party insurance, and it doesn't go through the physical therapist, then you would have a different deal. So that's the fine line of how I see we hold a neutral position. When we fall off to the support side, we fall on the side of the profession. If we fall, and that is where this legislation points us to. I'm saying in principle, absolutely, but in terms of what the board's position is, as a public protection mandate, the first consideration is not the financial interest of the profession. And there's that fine line that we find ourselves having to walk all the time. It may be just, it may be fair, it may be all the right reason, but it just falls slightly outward on the support side onto that other deal. So, but, you know.
I appreciate your caution, definitely, because you're absolutely right. Anytime that the profession benefits financially from something, the board usually should not get involved. But I think this is a unique situation where we can protect the public and protect our licensees. I think it's a yes and situation, not one or the other. So I would try to be careful about the duality that you're sort of creating by separating the two. I think that...
If I may also, the public protection, I think there was some mention about availability and quality of care. And that is directly pertaining to the patient.
It looks like it.
I need to...
You see, it's kind of interesting because it looks like it's a directly public protection deal. But because there's a commercial incentive that is dominating the front end of this, it kind of moves you a little bit closer to playing the border. And in what our mandate specifically said, if those things are ever weighed against, public protection weighs more. And if public protection weighs more, it needs to be the principle. And in this point of view, just the mechanism by which it is flowing through a commercial setup that is created by a market system, where someone saw an opportunity and exploited it, good or bad, if you step into that space, then every time the secondary part, you would have to support, well, not you would have to, you set a precedent for that being the way that a decision is made. When the first line to achieve it, I have to benefit the physical therapist, then I will affect public protection better. Then there's that, for me, that is a very slippery slope out there for the public mandate and the core reason for the existence of boards. Associations on the other side, you can fight them all day long, and that's great. And by us having a neutral position, we actually do support you, but we just can't say it. Because it's obvious that the board does support it, but there is a public protection mandate that actually dominates the conversation ultimately. And whenever you bring in finances, and here's the public, even if it achieves that goal secondarily, like it does in this case, you're outside of the mandate sphere. And that is my concern with this particular bill, that we are in a neutral position, it's playing out. And maybe it will play out, and it will continue to play out.
I appreciate your thoughts, TJ. Knowing who the author of this bill is, I can tell you that that is not what this is about at all. This is not about a financial gain to the physical therapist and the other providers. This is not just about PT. If you look at who else is involved, who else is supporting, the other organizations that are supporting this, this is not just CPTA. CPTA is the sponsor, but Senator Hill, who is the author, would not ever take on a bill, author a bill, and be behind something that would look at providing financial gain to any individual group. He is so intently focused on the support of workers' comp system and the adequate care and provision of care, accessibility to care by the members of the public, by the people of California, to be able to access those systems. It would be the furthest thing from his background to do that. And while the provision of care is one thing and the accessibility of care is another layer to this, the ability for physical therapists or any other providers who will be part of this, who will be affected by this, enables the patient, the injured worker, to be able to get care, appropriate care, timely care, and proficient care.
And I respect that. And that is actually true. That he did do, Senator Hill did do that with that intention. I don't even argue that point. The point that I'm arguing is that the people that back it has that first layer, like in the association, to protect their members. That's their responsibility. That's their role in this, in the environment that we are operating in. That's their role. The role of the board, on the other hand, is a public protection role. And so that falls first. No financial interest happens before that. You see, so when the association, and they back all of this, they support this, the association, California Physical Therapy Association, Chiropractic Association, that's their role. When you bring the board into it, which is not an association, which is primary mandate for existing is the public protection, and that public protection now falls as a secondary next to the financial or the commercial interest of the particular profession, then that is just a little bit outside of the mandate of the board, but well within the boundary of the Physical Therapy Association. And in this case, how I view it, that us having a neutral position is actually a supportive position in holding our mandated role as a public protector. That's all. That's the primary point I want to make.
So I believe we have a motion and a second.
And a second.
Any further discussion by the board? Any further discussion from, oh, yes.
If I may suggest an edit to the motion to flesh it out just a little more. Wording that I might recommend for Ms. Ellerby. I don't know if you would like to read it.
Ms.
or if you-
McMillan made
Oh,
it.
Ms. McMillan made the, if you would like me to share. Potential language could be, move that the PTBC adopt a position of support for SB 537 and authorize the executive officer to draft a letter of support to be submitted to the bill's author, the chair of the Assembly Business and Professions Committee, and the governor should the bill in its current status be enrolled.
I accept that amendment to my motion.
And I second the amendment.
After attending yesterday's board member orientation training,
Nice plug.
This seemed to be a good way to go.
Any further board comment? And any further public comment? Okay, roll call vote. That would be you, Mr. Kaiser.
1 second. I'm still capturing.
I have it if you want it.
Okay, roll call vote. Dr. Drummer?
Aye.
Katarina Ellerby?
Aye.
Jesus Dominguez?
Aye.
Alicia Rubina, amen.
Aye.
TJ Watkins?
No.
Tanya McMillan?
Aye.
Motion passes. And we will straighten out the motion itself. And that concludes the legislative report.
Sure does.
Sure does.
Okay, so it might be a really good time to recess for the afternoon.
Public comment.
Oh, any further public comment? Any public comment on issues not on the agenda? No? What's that? Yeah, I'm officially referring to agenda item number 9, public comment on items not on the agenda. Okay,
Madam President,
yes.
I would like to request a formal introduction and recognition of the gentleman to your right.
Yes, and so we are joined today by Michael Knutz, our new legal counsel appointed to the board. We'd like to welcome you to the Physical Therapy Board of California and thank you in advance for all you will help us with and contribute. Welcome.
Thank you. It's an honor and pleasure to be before the board and assist the board in any way I can.
Thank you, Dr. Drummer. Yes. Okay, so the time is 6:26. And we're going to recess until tomorrow morning.